I also have my assistant district attorney, Zach Young. He runs my criminal division, and my chief investigator, Michelle Bays, who runs our investigations unit, in here as well. They wanted to be here to just kind of hear the interview, but I'm fully prepared to answer questions you may have.
Great, yeah, the more the merrier. So yeah, just before I get started with my questions, I'll just give you a rundown on what I'm working on. I'm working on kind of a story about the implications and how things have been operating in the DA's office this year with the policy that I believe was released late December about plea bargaining and charging standards. So my questions are going to be mostly about that. I guess just to get started, I'm hoping to get a better sense of the rationale behind this policy and why the office, I guess, decided that it would be beneficial to have it in place and have it publicly released.
Okay, well, let me answer that. The first question I would ask of you is, have you read them?
Yes.
Okay, good. So you have a good understanding of what they say, or at least you can refer back to them.
Yes.
Because I think it's important. I don't want to. It's a large document. We spent a lot of time on it. I don't want to try to get that far down into the weeds with you, and hopefully you can just kind of read it so you can get the general philosophy behind it. But the first thing I guess I would say to answer your question is charging and plea bargaining standards are not a novel concept. They're common throughout our country. The Department of Justice, for example, has charging and plea bargaining standards that dictate how all the different U.S. attorneys in our country handle cases. DA's offices across the country also have plea bargaining and charging standards. So it's nothing new as a concept. It is something new to Washoe County. So what are the Washoe County charging and plea bargaining standards? It's a formalized policy that guides our prosecutors in their decision-making process when charging and negotiating cases. And as you touched on, we've been fully transparent about these standards, put them on our website since inception, which you're right, it was in, I believe, mid-December of 2022. The goal of the standards, as is the case with pretty much any charging and plea bargaining standards, is fairness, consistency, and objectivity in how we handle our prosecutions. And we believe our charging and plea bargaining standards are in line with what our community expects of the office. But I know you mentioned you want to talk about the plea bargaining component of the standards, which I'm happy to do. But what I want to point out to you is it's really important to note that there's two components to these charging and plea bargaining standards. The first is the charging standards, and the second is the plea bargaining standards. The charging standards are in place to ensure that cases that are submitted to our office by law enforcement for prosecution have reliable and admissible evidence that support proving the elements of each case beyond a reasonable doubt, which is the burden of proof that we operate under. The plea bargaining component of the standards is in place to hold serious offenders accountable for their primary crime or crimes that they've committed, with a focus on protecting the public and crime victims while ensuring that justice is served, because that is our primary mission. As you can tell by reading them, I'm sure, they prioritize the most dangerous criminals in our community: habitual criminals, violent offenders, and serious felonies. So that's kind of the basic overview of what the standards are. As to, I don't know, let me ask you, did you have any other follow-up questions based on that before I get into why we adopted the policy?
No, that was helpful, and yeah, I mean, I actually talked to some national plea bargaining experts, and they said that this kind of document, it's rare to be this transparent. So I appreciate the transparency that this document provides. But yeah, if you're willing to go a bit more into detail about the rationale behind this, that would be really helpful.
Yeah, Eric, well, I appreciate you saying that, because that is something we strive for. We believe as a prosecuting agency, we should be as transparent as we can be, because we work for the public and we really have nothing to hide. So that's kind of been a philosophy of mine since I took over as DA, and I'm glad to hear that a national expert recognized that. So as to the creation of the policy, why now, I think is kind of, why do we do it and why now is kind of your question. We were actually planning to create this policy in our office right before COVID hit. But like so many things in our world, it was put on the back burner once COVID hit and disrupted so much of our operations. But in mid-2022, we refocused our plan to create these standards, and there were several reasons why. The first off is we wanted to ensure that there was consistency in the provability of cases being submitted to the office by law enforcement for prosecution. And we wanted to ensure there was a consistency in plea bargaining of cases being handled in the office. Another factor in why we did it in 2022 is there were a lot of new deputy district attorneys that had been hired in our office. And we felt that it was an opportune time to create this policy and that they would benefit from this formalized guidance. The other reason is, in addition to some new deputy district attorneys, there was a lot of new law enforcement officers in our community. And we wanted to make sure that, again, there was a formalized policy that would help them understand, what the criminal justice system requires as far as proof for cases to be prosecuted. And we wanted to make sure that our law enforcement partners understood that probable cause policing, arresting somebody just based on probable cause, is insufficient for a prosecutor's office. So part of it is to help train law enforcement as well. So that's really the rationale behind it, and what it stands for.
Yeah, that is really helpful. And so I guess diving into some of the specifics in the policy that some people in the Northern Nevada legal community have flagged for me is in regards to how plea bargaining works. And a couple of lines that stood out to me, at least, were that a defendant will normally be expected to plead guilty to the most serious charge or most serious degree of charge that reflects the nature of their conduct or go to trial. While there's also a note that there are some circumstances where the most serious degree of charge may not be necessary. And then also the fact that a prosecutor can't offer or accept a plea bargain to a charge other than the most serious charge without the approval of their team chief. So I'm wondering if you could explain a little more in detail the rationale for those policies and what impact you've seen those policies having in the past year or so.
Sure. So again, you've got to look at this entire document when you consider these questions. So the charging standard, which is really step one. I mean, that relates to when a case first comes to the office. We are requiring that law enforcement is giving us cases that have a provability that meets our burden of beyond a reasonable doubt. So the charging standards ensure that well investigated and provable cases are in fact in the office, and that's very important, and I think that's what everybody expects. We take charging somebody with a crime very seriously, And if we're going to do that, we want to make sure that there is absolute proof to meet our burden in that situation. So keeping that in mind, when we have cases in the office that meet that expectation, the next step is the plea bargaining standard, and what you mentioned, the expectation that someone pleads to the primary charge. And really, Eric, if you break it down, all that, what that stands for is telling somebody that in our serious cases, we expect a defendant to plead guilty to the crime that they committed. And again, as I said before, we believe that that's what our community expects. Now, just because we ask somebody to plead to the most severe charge that they committed doesn't mean that we're going to be asking the court for the most severe penalty. And I think that is a very important concept for you to understand, and I want to explain it to you as best I can. But just because we're saying, look, you have to plead guilty to what you did, which is typically the most severe charge, we're not saying now we're going to turn around and go to court and ask for the most severe sentence. And I think the best way to give you some context on that, Eric, is to give you an example. So imagine if somebody was arrested for burglary and the case came to the office and we screened it and it met all the charging standard expectations and we charged it. The deputy district attorney who is going to offer a plea negotiation, who doesn't have to, plea bargains are not required in the system, but we do it routinely. But the deputy district attorney who would then make a plea offer has a broad range of options under the sentencing scheme for a burglary that has been set by our legislature by statute. So, for example, on a burglary case, we could go all the way from arguing for prison, and that could be within the sentencing range of 1 to 10 years, because that's the sentencing range on a burglary. We could also agree to recommend probation, which is another option under a burglary offense. We could also agree to recommend diversion. And so there's a lot of sentencing options within an individual charge. So if anybody is telling you, because I've heard this narrative myself, Eric, if anybody is telling you the Washoe County DA's office is not giving plea negotiations, that is patently false. We are regularly giving plea negotiations, and as I just highlighted for you in the example of a burglary charge, what we decide to offer, whether it's diversion, probation, or actually arguing for a term of months in prison, depends on the facts of the case and depends on the defendant's criminal history. And that, again, is kind of dictated by the plea bargaining standards. So although that might have been highlighted to you by defense attorneys in the criminal bar, they're pulling your leg a little bit if they're saying we're not offering plea deals, because all we're doing is saying, look, we're asking the defendant to plead guilty to the crime they committed, but we'll still work with you within the sentencing ranges on a plea negotiation, depending on what the facts of the crime and the defendant's criminal history would suggest is justice. Does that all make sense?
Yeah, that does make sense. So I guess one thing I'm wondering is kind of looking at it from, like a cost-benefit analysis from a defendant's perspective. So when I'm thinking about the incentive for a defendant to plead guilty to the most serious charge, would the incentive be that they may face a lower sentence if they plead guilty initially than if they plead not guilty and are found guilty in trial?
I'm sorry, can you say that again, Eric?
Yeah, so I'm trying to think of just the incentives of on the defendant's part to plead guilty to the most serious charge, and I guess what would you say the incentives are for defendants to plead guilty to the most serious charge?
Well, that's a good question. So the incentive resides within what the sentencing recommendation is going to be. And I would also say to you that fairly routinely in the office, we offer to dismiss other charges that are connected to the primary charge. So for example, again, if we use that burglary example, it's not uncommon that someone might be arrested for a burglary and also might be arrested and charged for possession of stolen property for, let's say, the property that they have in their possession from the burglary. We routinely offer to dismiss the other felony in exchange for them pleading guilty to, again, the primary charge. And then the incentive would come from what the sentencing recommendation is going to be. You know, and I think you touch on an interesting point that I believe, again, is very important to highlight. And that is, at the end of the day, whether or not a case goes to trial is not up to me, it's not up to my office, it's up to the defendant. It is always the defendant's decision if they want to plead guilty, if they want to accept culpability for what they've done and ask the court for leniency, or if they want to exercise their constitutional right to go to trial. Either way, my office's objective doesn't change because our job is to protect the community and ensure that justice is served. If it's going to a trial, that's fine. If it's negotiating a case in a way that we feel is just, that's fine too. But I think, interestingly enough, Eric, I have a case that just went to trial last week that I think would really kind of highlight what you're asking here is in terms of incentive. And I'll give you the guy's name, and we can give you the court case number if you'd like it, so you can verify all this. But this case actually went to trial just last week, and the defendant's name was William Stevens. And Mr. Stevens was found in a parking lot of a gas station here in town. He was passed out behind the wheel of his car. The engine was running, his foot was on the gas pedal, and the engine was actually revving, and someone called the police. Police showed up and woke up Mr. Stevens and realized, one, that he was under the influence of drugs. They discovered that in his waistband he was carrying a concealed pistol, which is a felony. He was also in possession of methamphetamine and heroin, both just possession of a controlled substance, so it wasn't large quantities, but still felonies. And he also had in his pocket a collapsible baton, which is a dangerous weapon. That's also a crime to have in your possession. That's a gross misdemeanor. But you know, Mr. Stevens didn't have a really lengthy criminal history, and he clearly had a drug problem. So what my prosecutor offered, pursuant to the charging and plea bargaining standards, was that if he pled guilty to the carrying a concealed weapon, the most dangerous charge, the primary charge, we would agree to dismiss the possession of methamphetamine, the possession of heroin, the possession of a dangerous weapon. We also told Mr. Stevens and his lawyer that we would agree to recommend probation so that he could address his drug issues. He would have an opportunity to hopefully straighten himself out. And if he did that, the charge could ultimately get dismissed. So yes, we were asking him to plead to the primary or the most severe charge, but we were still providing him with incredible incentive to plead guilty. Mr. Stevens didn't want to do that. He opted to not accept that plea offer after consulting with his lawyer, and they went to trial. And just last week we went to trial and he was convicted of all 4 charges. So now he's facing sentencing for all 4 charges. That was his decision. So, you know, we tried to offer something that we felt was just for our community and was just also for Mr. Stevens, and he opted not to do that. So that kind of gives you some context. And we have lots of examples like that, but this one was, ironically, I just got an update on it late last week. So I thought it might be something you'd be interested to hear about.
Yeah, that is helpful, and we're always trying to bolster stories with individual anecdotes, so that is helpful. I guess one kind of circling back to one of the earlier points I mentioned in the policy about how line deputies have to get approval from their team chief before offering any plea deal that's less than the most serious charge. What was the reason behind that change?
Well, that is, again, I want to make clear to you that if you look at the appendix to the charging and plea bargaining standards, there's a whole host of reasons why one might depart from the primary charge or this most severe charge. But what we want to encourage in the office is that if a deputy feels like a case should be, like they need to depart from the plea bargaining standards, we want them to consult with their team chief. That is their supervisor. Those are our most experienced prosecutors in the office, and we want to make sure that it's being vetted appropriately. And so in our office, just so you know, Eric, we have 3 felony teams that handle the bulk of our serious felony prosecutions. And there's 6 DAs on each team and then 1 team chief who assists them and supervises them. So again, we just wanted to formalize what's been a long-standing policy in the office. You go to your team chief when you need help with a case.
So I spoke with a couple of attorneys who used to be deputy district attorneys in the DA's office, and they said that this kind of arrangement wasn't how it worked when they were there. They were explaining how it was kind of, the chief was there as a support role, but generally the line deputies had full discretion over how to prosecute their cases, and they kind of took issue with this because they believe the policy is kind of taking away that discretion from line deputies who may know a bit more about the ins and outs of cases than their team chief. So I'm wondering if you have any thoughts on those concerns.
Yeah, I do. I guess my first question would be, are these deputies that came from this office?
Yes. So they used to be deputy district attorneys within the Washoe DA office.
And how recently in time are we talking about?
Late 2010s, I think. Yeah, I believe. Yeah, I think like mid 2010s to late 2010s.
2010s?
Like 2010, so like 2015 to 2019, I think.
Oh, okay. So that's, I guess that's somewhat true in the idea that we didn't have a formalized written policy at that time, but we've always had the structure we have in place right now, which is the team chief overseeing a group of prosecutors. I mean, I guess it's hard for me to answer. I don't know exactly what they said, but this policy is what is in place now. And that, like I've said to you, I've given you the foundation and the basis behind it. So we're striving to make sure that there is consistency and fairness and objectivity in the way we handle our cases, and we believe that this formalized policy is the best way to do that. And then kind of a question I've been wondering about the implementation of this policy, because I've been just like looking through different cases that have gone through the district court this year, and I understand a lot of times they are filed, say, November of this year, and then the plea wouldn't be like the not guilty or guilty plea wouldn't be for a few months later. So I'm wondering which cases this policy applied to. For example, if a case originated or was filed before this policy went into effect, but the plea wasn't until, or the arraignment wasn't until after the
the policy went into effect. Does this policy apply to those cases?
That's a great question, Eric. So this policy did not apply to any case prior to mid-December of 2022. Meaning,
and by any case prior, do you mean any case where the charge was prior?
Yeah. So I don't know how well you know the criminal justice system. It's very complicated, even for someone who's studied it a little bit. But so I'm going to give you a very basic overview because I think it'll help understand this answer. But in Washoe County, any felony that comes into our office that we're proceeding on as a felony has to start in justice court, which is a court of limited jurisdiction that handles kind of the preliminary issues involving felony cases. And after a case leaves justice court, it goes to district court. And district court is where the actual guilty plea or not guilty plea occurs, where the trial or just the plea occurs, and where the sentencing occurs.
Yeah.
And so somebody, when they're initially charged with a crime, is going to be in justice court first in almost all situations, with the exception of a few, and then ultimately into district court. What we made clear to our deputies is the charging and plea bargaining standards were not retroactive. So any arrest or formal charge that occurred before December of 2022, they did not apply.
Okay.
And I think what's a really good point to make here, and I would base this off one of the questions that you sent to Kendall, is the notion that our plea bargaining standards, our charging and plea bargaining standards, have some consequential effect on all the jury trials that are occurring in Washoe County this year. And that is just simply not true, because I can give you the numbers. So in Washoe County this year, my office has conducted 84 jury trials, which is an incredibly high number historically. Okay, now 80 of those cases have been in district court. Those have been felonies, and 4 of those cases have been misdemeanors for domestic violence. But the important takeaway is there's been 84 jury trials. Of those 84 jury trials, only 14% of them, or 12 of them, originated after the charging and plea bargaining standards were adopted. So 86% of the trials that have occurred this year predate the plea bargaining and charging standards. So
yeah, that is helpful, and it was I think I sent Kendall the data that we got from the court, and it was helpful to see like CR 23 and CR 2022 to get a sense of when these cases were originating.
So,
I guess another question.
One sec, Eric, sorry to interrupt you. Yeah, so you'd written back to Kendall and you said the main concern from community members is that the plea policy is resulting in an immense rise in cases going to trial. And I just want to make it very clear that the numbers simply do not support that. And I would be curious of what community members, if you don't mind telling me, you don't have to tell me the names. I'm just curious of who is making that assertion, because I can tell you as the district attorney, I'm regularly out talking to community members, and I'm very transparent. I share with them what we're doing, and I've heard no complaints about the plea bargaining and charging standards. I've even shared it with the judges in our jurisdiction and have not heard complaints from them either. So I'm curious, where you're getting that info, because it is inaccurate.
So I've spoken with 5 criminal defense lawyers up north, and it was all pretty uniform. So they all were pretty much of the same opinion that this policy had the effect of overwhelming the system. One thing I wanted to note was I looked on the district court's website for upcoming cases or upcoming calendared events. And in the next year, I found that there were 254 jury trials scheduled. I know a lot of maybe some of those won't take place and the case will get settled before then. But to me, at least, that struck me as a very, very high number. And 91 of those cases that have trials scheduled originated this year. So I'm wondering if you have any thoughts or insight into that or how that process works.
Yeah, I do. Again, I would suggest to you, Eric, that those numbers are not very reliable in terms of projecting how many cases are actually going to go to trial. And I'll tell you why, or I'll give you an example. It's not uncommon. In fact, it's very common that cases get set for trial and then ultimately are negotiated, or the defendant ultimately pleads guilty. And so while there'll be a trial setting, it doesn't always materialize into a trial. I'll give you another example of some numbers. And like I've said, Eric, we're fully transparent with all of this. We've got the numbers to show everything I'm telling you, and we'd be happy to share it with you. But so I reached out to one of the chiefs of one of my felony teams. So one of those teams that has 6 lawyers on it, one of the 3, and one chief, to ask them some insight on trial settings. And what I'll share with you is this year, just that one felony team had 109 trial settings, but only 23 of them actually went to trial. So that will give you some insight into, yes, cases get set often, but they don't always go to trial.
Mm-hmm. Yeah, and I guess one thing I'm wondering, because I imagine a lot of these, the trial settings for like the 109 trial settings this year were for cases that originated before this policy went into effect, so the policy wasn't retroactively applied to those cases. I think one concern that I've heard pretty uniformly from criminal defense lawyers is just that they don't really buy the incentive for defendants to plead guilty. So you mentioned that there, in many cases, people decide to plead guilty before the trial, but they don't really see that happening, and they haven't really seen that happening in their cases this year. So I'm wondering, they're of the opinion that a lot of these trials will take place because they don't think there's much incentive for defendants to plead guilty later on in the process, if that makes sense. I'm just wondering your thoughts on that opinion.
Well, I don't know. I mean, the first thing I would ask you is, have they given you any numbers to support what they're telling you?
No, they have not.
So, I mean, look, you're getting anecdotal information from, pardon my French, but from disgruntled defense attorneys. And it is not my job as the district attorney to make defense attorneys happy. Mm-hmm. My job, and I take it very seriously, is to protect our community, protect victims of crime, and make sure that justice is served, and to meet community expectations. And that's what we're doing. Now, again, that case example I gave you about Mr. Stevens, I did not cherry pick that case. It's not one that I'm like, ooh, let's use this one for Eric. It literally was a case that I just happened to get an email on, and I thought it would be interesting for you to hear. But I would be shocked for any defense attorney to say, or anybody in our community to say, that there was not an incentive for Mr. Stevens to plead guilty to the one charge and get the opportunity of recommended probation and the opportunity of the case to be ultimately dismissed if he successfully completes probation, and we dismiss all three of those other charges. I'd have a hard time imagining that somebody would say that there wasn't an incentive there. And he didn't plead guilty, and he ended up getting convicted of 3 felonies and a serious dangerous weapon charge. So, so I guess that would be my answer to your question is we're not here to make defense attorneys happy.
Yeah, well, yeah, I mean, I really appreciate all the insight you've had because, yeah, I mean, I think it's really important to get your office's perspective on this policy because you know the most about the policy because you're the ones that made it. But so those were the main questions that I had for you. But was there anything else that you think I should know or anything else you wanted to flag for me for my story?
Yeah, there's a couple things that I would just like to touch on. Have the individuals you've talked to given you any ideas as to what might be causing the increase in trials?
So they think it's because of the policy. They think it's because people are not pleading guilty and people are choosing to go to trial. And maybe not this year because, like you said, a lot of the cases originated from before the policy went into effect. But they're encountering cases where people are pleading not guilty and the trials are scheduled for a long way out because the schedule for next year is so booked. That's been the pretty common impression I've gotten from lawyers.
Okay. Well, if you're interested, I'd like to share with you why we think there's an increase in trials this year.
Yeah.
And then a couple other numbers that you may find interesting. But the first thing I would say is it's important to, or we believe the increase in trials is multifaceted. The first, we are still dealing with the COVID hangover here in Washoe County. And, you know, you don't have to remind anybody of this, but, you know, there was a complete shutdown of our system for a long period of time. But the unfortunate thing, you know, for my office is crime didn't stop. You know, we were not able to turn off the spigot that was sending felony cases into our office. And that is reflected in the trial numbers this year. This year, we are still trying cases from 2018, 2019, 2020, and 2021. And that's significant. That is, I believe, very much a product of COVID. Some of the other reasons we believe the case numbers are increasing is the population in Washoe County is booming as well. Additionally, felony case filings in Washoe County has been steadily increasing since 2015. The Nevada Supreme Court does an annual report that lists case filings in all the courts throughout Nevada. They're very informative, and what the Nevada Supreme Court reports show that since 2015, there's been a 56% increase in Washoe County of felony case filings. So those are our most serious crimes. Additionally, violent crime is up, and those are the cases that we prioritize. So that also is leading to, I believe, an increase. But then lastly, and I touched on this a little bit, another factor is a defendant's unwillingness to plead guilty. And that's an important fact that I believe has to be remembered, is at the end of the day, whether a case goes to trial lies directly with the defendant. You know, we make plea offers in the vast majority of our cases. And when that is done, the defendant has two choices. The first is they can accept culpability for what they have done and ask for leniency from the court for that acknowledgement. Or the second is to assert their constitutional right to a trial. Either way, my office still has the same obligation to hold that person accountable, and we do so. It is also very important to recognize the role of the defendant's attorney in the evaluation and negotiation process. So as I've said, we're fully transparent in our cases, just like we are in our office. We provide all the evidence to the defense. We're absolutely an open book. And at that point, when we've provided them all the evidence, we've given them a plea offer, it's incumbent on them to advise their client and fully discuss the risks of pleading guilty or taking the case to trial. But it's ultimately up to the defendant to choose, and our numbers seem to reflect that they are choosing to go to trial more. The other thing I wanted to share with you is you made this comment that it's overwhelming the system, all these trials. Now, again, Eric, I just want to make sure that this is abundantly clear. It is the increase in trials, the numbers do not show that it is because of our plea bargaining and charging standards in 2023. The numbers just frankly belie that narrative. But what I think is important to say, nevertheless, in the notion of this overwhelming the system argument, first off, Washoe County is a community of 500,000 people. Last year, just for context, we received 4,225 felony cases in our office, and we've only done 84 trials. So defendants are pleading, cases are being resolved. I mean, 84 trials out of 4,225 felony cases is such a nominal fraction that the notion that it's overwhelming the system is a tough one to accept. Additionally, I think this is an interesting point as well. There's 52 weeks in a year, and there's 5 business days or trial or courtroom days a week. There's also 9 district court judges in Washoe County, and those are the people who preside over the vast majority of our jury trials. So if you multiply that 52 weeks by 5 days a week by 9 judges, that gives you 2,340 available court days a year. Now, to be fair, let's subtract 200 of those available court days to assume for vacation and holidays. That puts us at 2,140 available court days a year in Washoe County in district court where our jury trials occur. To date, our trials have taken a total of 214 days. So that's 10% of the available court calendar days a year. And how that could be suggested to be overwhelming the system just seems inconsistent to me. The last thing I just wanted to say, and again, this was based off a reply that you sent to Kendall. And what you had written to her is, the main concern from community members is that the plea policy is resulting in an immense rise in cases going to trial, which is overwhelming the court system. I think I've made my points on that, but you also suggested, and resulting in defendants spending more time in prison while waiting for their trial. So I just wanted to touch on that last assertion. So first off, it's important to note that every defendant that we charge with a crime has a statutory right to a speedy trial. It's typically within 60 days of arraignment. Now, the defendant and his attorney have to make a decision as to whether or not they want to invoke that right or waive it. And that decision rests solely with the defendant and their attorney. If they waive it, they are accepting the fact that it will take longer for them to get to trial. Now, the next point that I think is interesting, if you look at the 84 trials that we've had this year, 40 of the defendants in 40 of those trials, so nearly 50%, were all out of custody. they had posted bail or were released on their own recognizance by the court. And I can tell you that that number is very inconsistent with what we've seen historically. Historically, it was a much higher number of defendants in custody waiting trial. And I believe that's a product of, policy adopted in our state recently regarding bail reform. But defendants who post bail routinely waive their right to a speedy trial. It's very common for defendants in custody to waive their right to a speedy trial after consulting with their attorney. But when they do that, their trial dates naturally get put further down the calendar. I mean, that is a product of, I don't mean to suggest we're not busy here in Washoe County, because we are very busy. The DA's office, the PD's office, the courts. But I would suggest that the numbers, again, just don't show that defendants are languishing in custody waiting for a trial when they've invoked their right to a speedy trial.
Mm-hmm. Yeah, I appreciate all of that. And yeah, that's really helpful, because I know you guys are treasure trove of data on what's going on in the county. I don't really have any main follow-up questions to those points, but again, is there anything else you wanted to mention that I didn't ask about, or anything else I should know?
I don't think so. Let me just take a quick gander at my notes that I'd put down here. I don't believe so, Eric, and like I said, I appreciate you reaching out to us, because it's important for us to be able to explain ourselves and dispel any myths that may be out there. The one thing I would offer to you, and I think would be an important thing for you to take us up on, is after you've had, I've dropped a lot of information on your head here. After you've had a time to kind of digest it, and I don't know if you're intending on interviewing other individuals or circling back with some of these people that have made these kind of bald assertions, but I certainly want to offer up to you the opportunity to speak with my staff some more. I'm a little harder to nail down with my calendar, but I want to offer to you both a chance to speak with Assistant DA Zach Young, or Investigator Bays, or Kendall, or all three of them, if you have any follow-up questions. Because like I said, I'm not trying to suggest you haven't done your research and you don't know the issue, because I believe you do, Eric. I'm appreciative of your preparation, but the criminal justice system is very complicated. And I think if there are any holes out there that you need filled, we're happy to answer any questions and provide you any numbers. So I would encourage you to reach back to Kendall, and if you have any other questions, or you've reviewed your notes and listened to this recording and you're thinking, well, what about this, what about that? I want to give you that opportunity to talk with us again, because I just want to make sure all the information is out there.
Mm-hmm. Yeah, well, I really appreciate that, and yeah, you're right. I will have to kind of digest everything that's been discussed today. So, I'll be sure to reach out to Kendall if I need any clarified questions, or if I want to speak with more people.
Okay, Eric. Well, nice chatting with you. It's good to meet you.
Nice chatting with you as well. Hope you have a good rest of the week.
You too. Bye-bye. Bye.